things that folks need to consider is the peace of mind for your family. Because if mom and dad transitions into long-term care with planning, then the children don't have to worry about how they're going to cover mom's or dad's care. With proper planning, again, they've got a roadmap, if you will, that gives them guidance at the various stages to help reassure them, that at any point in time, mom and dad are going to be properly taken care of. There's going to be enough money, or there will be proper assistance from the state, and money is, and possibly money set aside to supplement that care, whereby they just don't have to worry about, the monthly bill that's going to come due when it comes to mom or dad's care. So when I talk to my folks, I talk about, the different stages of planning. Most folks think about what happens to my assets when I die, so we consider that after death planning. You've passed on and you've set aside, hopefully you've got a will in place that says, this is where, who I want to receive my assets and how, who, when, and how, my assets will pass on to my loved ones. With this type of planning, we're talking about what if I live? What if I live long enough, again, with the aspect of what if I live long enough and end up in a long-term care community? That's where this type of planning becomes very important. And, on one end of the spectrum, there are power of attorneys, where if you can't make your own decision, you can appoint a third party to, make healthcare or financial decisions for you. And then as as our loved one transitions potentially to the need for long-term care, that's where some sort of asset preservation planning, possibly with the use of trust, again, can help create a situation where the family, while they're having to focus on care, hopefully aren't having to worry about the amount of money that's available to pay for mom and dad's care. I always say that one size does not fit all. In my opinion, this type of planning is specific to the family. There are different aspects of that particular family situation that we have to look at and that we have to consider when doing this type of planning, which we call typically asset preservation planning. That's where generally we could talk about trust and, again, other type of planning techniques to hopefully, again, achieve their desired result for the family. It's sort of a holistic way of looking at planning. Again, we're not looking at any one particular thing. We're looking at everything. And when you're talking about trust, that is very important. I'm asked all the time, can we use trust? And so I have to ask folks a lot of questions, whether it makes sense for them to use a trust because of the potential effects, whether it's positive or negative, that implementing a trust or any other type of plan for a particular family is put in place. So we have to ask about the health. If there's been a diagnosis already of Alzheimer's or Parkinson's, that is one variable that has to be considered. The anticipated level of care. Some folks may need skilled care. Some folks may only need assisted living. A lot of folks may have the ability to stay in their own home and bring care inside the house. So that is one aspect to consider before making a particular recommendation. Family makeup. Are my clients married or are they single? Again, are we talking pre-planning? Are we talking crisis? Are we working with a first marriage, only marriage, or are we working with a blended family, which has its own set of needs and criteria that need to be taken in consideration before implementing a particular plan? Their character of the assets, whether it's real property, liquid assets, bank account savings, IRAs, tangible personal property, if you have collectible vehicles, life insurance, you name it. All of that has to be taken consideration in deciding what makes the most sense for a family when they sit down across the table from me. And usually when we start talking about trust, we're talking about the implications of using a trust in combination with some form of public assistance, whether that's Medicaid, special assistance, or assistance from the VA if you are working with a wartime veteran or their spouse. Each program has their own requirements with regards to level of assets, gifting, income. There are all these different factors with each different program that may be available to the family that have to be taken consideration with trust. With Medicaid and special assistance is a program here in North Carolina that helps cover assisted living care. The applicant, if the loved one who's the applicant can only have $2,000 in the bank, versus the VA. Right now, the VA, which they just amended their rules recently, allows you to keep a little over 120,000 in assets. So again, if we're looking at Medicaid, we know the applicant can only have $2,000 in countable assets. Excuse me, I didn't mention that, clarify that early. So applicant can only have $2,000 countable assets for special assistance Medicaid. VA can have up to over roughly about $120,000. So knowing that a person going on Medicaid can only have $2,000 in special assistance versus someone who may just tap into VA and knowing they can have more money, again, kind of controls that dialogue, if you will, with regards to, does it make sense to use, an irrevocable trust? Can we get away with using a testamentary trust? Can we use a third-party trust? Again, we want to make sure that based on family dynamics, character of assets, and the particular program that the family may tap into later on, that we put something in place that's going to work for them and not against them. As I mentioned earlier, again, each program allows an applicant to keep, a certain amount of money. We call that means tested. That means when you apply for benefits, that they are going to, that whether it's the state of North Carolina or if it's going to be the VA, they're going to go through your financial records to see what you own at that particular time. And again, there is a difference, especially in the Medicaid and the special assistance arena versus VA. If you're single, again, you can only have $2,000. If you're married and have a healthy spouse, there are protections for that healthy spouse. But the VA, it's just lumped in all together. Whether they're single or married, they get to keep a certain amount of assets. And so we want to make sure that if we have a married couple who anticipates that they may apply for Medicaid, we want to set aside enough money for the healthy spouse to make sure that they can continue living at their accustomed lifestyle, whereby the applicant, again, only has $2,000 legally in their name when they apply for benefits. And so, again, assets coupled with level of care, we'll control that conversation as to what makes the most sense, for, the family. Look back is something that a lot of folks are familiar with. I meet with folks often, and, they are familiar with the look back period. So I'm always asked, what about the Medicaid look back period? Now, there's a 5-year look back for Medicaid. So that means when assets are transferred from the ownership of the applicant to a third party, social services will go through 5 years worth of financial records to see where that money went. With the special assistance program, that look back is 3 years. And with the VA did not have a look back period in the old days. Now they do. The VA also has a 3-year look back period with a gifting penalty attached to it. So regardless of whether it's Medicaid, special assistance, or VA, when families transfer money to a trust with the purpose of shielding that money to protect it in case there's a long-term care event, when you transfer money from the individual to a trust, that triggers that look back. And so, and each program has its own penalty period applicable to it. So with Medicaid, if you transfer assets to a trust, a Medicaid-friendly trust, and then apply for benefits, if they find that transfer within 5 years from the date of application, they're going to assess a penalty. With special assistance, it works a little different. You put money into a trust, the penalty period starts to run immediately, or the look back period 3 years. So they look for 3 years, but the gifting penalty works a little different for special assistance as it does for Medicaid. And with the VA, same thing. VA has a three-year look back. So if through their examination of 3 years worth of financial documents, they see a transfer to a trust, then they determine, then they look to and calculate and determine whether there should be, an applicable penalty period assessed for that transfer to the trust or to an individual. So we use Medicaid as kind of as a guiding star. So if I'm talking to families about trust, I want to make sure that they can beat that 5-year look back period. That's the key. So we want to make sure that if we use a trust, that we don't interfere with the family's ability to pay for care and at some point, tap into public benefits. And right quick, I'm almost out of time. The different types of trusts that we talk to folks about are revocable, irrevocable, testamentary, and special needs. Revocable trust, which is great from a probate standpoint, does not work for asset preservation purposes. Whether it's the state of North Carolina or the VA, they consider revocable trust, any assets held by a revocable trust as available to the applicant. So they don't work. So we have to look at some sort of irrevocable trust that puts conditions on access and use of that money. In general, though, when you use an irrevocable trust, the principal, the person setting up the trust gives up the ability to use the principal, which is the money they're funding it. They may retain the right to income, but they cannot access that money for the rest of their lifetime. They're giving it up. And if it works, then at the right time, they apply for benefits, then they've set aside enough money to, again, help supplement care and hopefully pass on some to the next generation. And that money is not counted against them for Medicaid, special assistance, or VA purposes. I'm out of time. I'm sorry, that was a lot of stuff to cover. I tried to get through it as quick as possible. If you have any questions, please make sure you ask them before we all leave. Thank you for my time tonight, and thank you for having me.
Yeah, that was great, Steve. Thank you very much. There was a lot of good stuff in there. I'm going to go ahead and share my screen with everybody because I've got a few slides that I want to share. Okay, slides are up. Bruce, we're good? Okay, yeah, thank you for having us tonight. Bruce, Jennifer, glad to be here. Steve mentioned a really important statistic that kind of drives a lot of what we do here at Richard Roach, and that was the statistic of 70% of people over age 65 at some point in time will need some type of long-term care. That could be assisted living, that could be skilled nursing, that could be in-home health care. And so in our practice, about 7 years ago, I had a very dear friend and partner of mine, that's the Richard in the Richard Roach, who experienced a skilled nursing stay for several months here at Camden in Greensboro. And he was one that had done a lot of planning. And as we were talking before we got started tonight, you got a couple options as it relates to the financial side of long-term care. You can either be proactive with it or you can be reactive with it. A lot of what Steve has already shared with you, really from the legal side, is being proactive with the use of trust and trying to plan ahead. Because as he stated, with Medicaid, you basically have to spend things down to a very nominal level before Medicaid is going to kick in. And at that, you don't really have a lot of choice in what your level of care would look like from a Medicaid standpoint. Whereas if you are proactive and have done some things ahead of time, then you have a lot more control over the place that you might go or the type or level of care that you might get. So we tend to focus a little bit more on the asset preservation planning and tools to do that. There are several financial tools that we use to basically position folks in a way that they have a little bit more control over what long-term care would look like for them. So again, I think it's a very important statistic to know what those look like, that the chance is really high that you're going to need some level of care. So as part of our due diligence, this is a list of some of the important documents that I like to see from folks in our office. And this was really getting into the weeds here, but it's so important to have things like brokerage statements, tax returns, life insurance information, annuity statements, any types of trust. If there's a POA, we like to see a copy of that as well. Believe it or not, mortgage statements can be helpful to look at. Pension statements, any will that you might have, long-term care insurance, anything that you might already have in place. Maybe you have an old pay-as-you-go type long-term care policy. Well, we want to review that. What's the dollar amount per day that that policy is going to pay? What's the premium on that contract? So there's a whole lot that comes around the insurance side that we want to review and see if it's going to do what it was planned or expected to do when it was originally purchased. Social Security statements are important. Disability insurance information is important. Banking documents, just to know how things are set up. Are things payable on demand at the bank if something were to happen or needed by by the adult children here who may be taking care of a parent. So lots of documents there that are very helpful, that help us to see things a little bit more holistically. And to me, the biggest advice I have is to look for an advisor that has some knowledge, some working knowledge in the long-term care space, more so than just pay-as-you-go type contracts, as we call them with long-term care. What we like and what I'm going to share with you are a couple concepts called long-term care hybrid policies. These are basically contracts that will utilize either life insurance or annuities with long-term care riders on them. These are fantastic asset preservation type tools that people need to be aware of. And as I get out in the community and do more and more talking about this type of planning, folks aren't aware of this. They're aware of the older pay-as-you-go type contracts, but the downside that I've been seeing over the years with that is that as folks start to get a little bit older, they're starting to get notices from these insurance companies saying that their premiums are going up, and they have an option. They can either pay that higher premium or they can decrease the benefits, neither of which is a good scenario, because as you get older, the chances are getting greater that you're going to need it in an inflationary environment where the cost continues to get higher. So if in an attempt to keep premiums in check, they will decrease the benefits, which is polar opposite of what is actually needed at that time. So the pay-as-you-go type contracts I'm not a big fan of those. If you've got them, I'm not suggesting that you need to let them go, but I think they need to be reviewed, by an advisor so that you understand what you have and what you're paying for. And then it could possibly work with some of the other ideas that I'm going to share with you, this being the one. So in a nutshell, the life insurance long-term care type hybrid policy is a contract that basically utilizes the life insurance mechanism coupled with a long-term care rider. So it's driven by the definition of meeting 2 of the 6 activities of daily living. So if I can't bathe myself and feed myself, then my contract opens up and is available for long-term care. So I'm going to give you a little example of what this looks like. You've got 2 things happening here. You got a premium that you're paying for the policy. It might be a single premium, or maybe you're paying premiums over a monthly or annual basis or something like that for a life insurance contract. It works both ways. I have a death benefit that comes out one side if I were to die, but if I'm living and I need it and I've qualified for long-term care by meeting 2 of the 6 activities of daily living, then my contract opens up for long-term care. So let's just say hypothetically, I've got a contract that's $200,000 in life insurance. And let's just say I need that for long-term care because I've met the 2 of the 6 activities of daily living. Well, most contracts will give you a percentage of the death benefit that can be used for long-term care. Oftentimes that's around 2%. So if I've got a $200,000 policy, 2% of that policy, which is $4,000, could be distributed per month for my care for up to 50 months. Very important to note that that's a tax-free benefit that is paid out. So if, let's just say in the, we'll call it the imperfect world, but kind of the perfect world, if I needed it for exactly 50 months and it was paying out $4,000 a month, then it will have completely liquidated my $200,000 policy in the form of long-term care benefit tax-free. Let's assume a scenario where maybe I only needed it for a year and then I passed away during the end of that year. Well, it's kicked out $4,000 a month times 12 months, which would be $48,000. Then I die. The benefit to my beneficiary would be the $200,000 initial death benefit minus the $48,000 that was paid out for long-term care. So the net effect of that is that $152,000 is what would be going to my beneficiary. We love this strategy when the person is insurable. And for those of you that are adult children, and maybe you're already down this road with your parents and something like this isn't available, this is something that you might want to be looking at. I'm in my mid-50s, and I do have aging parents. And we have done things like this to help secure things down line. But we do know, too, that the younger you are, the cheaper it is. The older you get, the more expensive it gets. And if you develop any type of health conditions, then again, that can get a little bit more expensive. So we like the use of a life insurance contract with a rider. And this is an example of one just paying out where you've maybe got in this instance, somebody paid a $250,000 one-time premium into a contract, and it created a $500,000 death benefit and long-term care benefit. So in my example here, this person needed $270,000 towards long-term care, and when they passed, the remaining $230,000 went down line to the beneficiary. Again, this is asset preservation at its best when you can afford to do that and when you're insurable enough to do that. So again, we like that strategy for preservation and all. Another example of utilizing life insurance like this rather than just a single premium, this is one where you're paying premium into a contract, and maybe you had some rollover from an older policy. These older policies don't have long-term care riders in them. But in my example here, we were looking at a $45,000 that was in cash value of an existing contract, and just rolled that money through a 1035 tax-free exchange into a $350,000 life insurance policy with a long-term care rider. So that came at a premium of $5,000 per year. On the left-hand side of this slide, what you are seeing was the way the contract was set up for this particular person. They initially were paying $3,000 a year for a $100,000 life insurance policy, and they were paying $5,000 a year for a $150,000 long-term care benefit, which would be one of the pay-as-you-go type contracts. So in this example, you're seeing that she was paying $8,000 per year and was trying to do it in two different ways, one with a life insurance policy and one with a pay-as-you-go long-term care contract. So what we were able to do was transition over the $45,000 of cash that was in that $100,000 policy and get her a contract for $350,000 at a total premium of $5,000 per year. So again, it's one reason that gathering those documents that I mentioned before is so important, because if you bring those things in and we're able to see what you've got, we're able to put something together that may be more beneficial for both you and your beneficiaries. So again, life insurance with a long-term care rider. This next slide is an annuity with a long-term care rider. And this is a really cool concept because this is one that my partner actually had at the time. So in this example, we have an annuity where the applicant has put $100,000 into this annuity. And the way the annuity works is you pay a small fee for the rider. The fee is about 1.4%. Again, it's a little bit tied to age of the applicant too, but the cost of the rider is about 1.4% per year. The annuity itself credits interest at the rate of about 1.9%. Again, these change a little bit, but you can see that if I'm earning 1.9 and I'm paying 1.4 for the rider, then I'm netting earnings on my $100,000 of 0.5%, which is probably more than what most people are making in their bank savings account. In this scenario, we've got a person that maybe they had $200,000 or $300,000 or $400,000 just sitting in savings, and they're thinking, well, this is my long-term care bucket of money. Well, the way this annuity works, if we reposition the $100,000 in this example here, then this annuity, if this person meets 2 of the 6 activities of daily living, would pay $50,000 out in year 1 for care, $50,000 out in year 2 for care, and then it will pay 3 more years of 50, 50, and 50 because I paid 1.4% for the rider. So this is a way to create a total long-term care benefit of $250,000 because you used an annuity that had a long-term care rider. Again, a beautiful strategy for repositioning assets that maybe were designed for long-term care, but the banks aren't going to give you a 2.5 times return on your investment if you become disabled due to a long-term care need, 2 of the 6 activities. So this is a wonderful strategy for repositioning things in a manner that can create some additional long-term care that folks just aren't aware of. So again, we love the annuity with the long-term care option in there as well. You know, in closing, again, I just got a couple minutes, and I know we'll have some questions at the end, but I think it's so important to have a written retirement strategy, or at least review the one that you have. Again, those documents are so vital in any proactive planning that you can do with an advisor, which encompasses using somebody like Steve as an elder care attorney and bringing in an advisor, maybe even talking to the CPA kind of about where your parents' assets are positioned, or just looking at your own. All of those things come into play when you are trying to either plan for yourself, or maybe you're trying to plan for a parent who's getting there but hasn't quite gotten there in terms of the need for the for long-term care quite yet. You know, so that's I think all important things. And if anybody has any questions, I know we're going to hold those to the end, but you know, appreciate the opportunity to share this with all of you. I think it's really important, and I'm glad that Bruce and your group at ACAP has put something like this together, because there are a lot of tools out there that folks just aren't familiar with.
Okay, all right. Well, thank you, Bill.
Appreciate
that information. Move on to Kevin Pearce.
Good evening. My name is Kevin Pearce, and I'm the manager for medical outreach for AuthoriCare Collective. That's a mouthful, isn't it? We are hospice and palliative care of Greensboro and hospice and palliative care of Alamance-Caswell. These two wonderful hospices merged in October of this previous year and formed one of the largest not-for-profit hospices in Central North Carolina. We service almost 11 counties now in Central North Carolina. And it is a privilege to work with them. Tonight, we're going to discuss advanced care planning. What is exactly advanced care planning? Oftentimes, these are difficult conversations to have with other people. You will often hear advanced care planning referred to as advanced care planning or advanced directives. They're the same documents, just by different names. But advanced directives are a set of directions that you give about the health care you would like if you ever lose the ability to make decisions for yourself. So these are documents that ensure what you or your loved ones want to have happen in case you cannot say it for yourself. But how in the world do we go about getting these documents into place? And how do we start these difficult, often difficult conversations to have with our loved ones? Perhaps we could start with a simple truth and simply say, Mom, I love you. I worry about your well-being. It makes me scared to think about you being in a medical crisis, but it scares me even more to think that I might have to make decisions for you without knowing exactly what you want in these situations. Another option is, Dad, I know this isn't easy to talk about, but if you get sick or have an accident and can't make a medical decision for yourself, I want to know what would be important to you. So I or someone else that you choose can be your decision maker. Finally, I thought a lot about what happened to Sally's family when her mother went into the hospital. And I want to make sure that I know what you want if you were ever in that situation. Often these kinds of gentle introductions will give you an opportunity to start these important conversations. But when is the best time? Well, on what we call the road of life, if we are healthy adults, two of these documents this is the best time to complete two of these documents. One is called a living will, the other is called a healthcare power of attorney. And we'll discuss both of these at length in just a few minutes. But as healthy adults is the best time that we can get these documents completed and get them in place. If we have a disease, a serious illness of some kind, and that serious illness advances, then we most likely want to consult with our physician and complete another advanced directive called a MOST form, which is a physician's order. It is a medical order for treatment that a physician will fill out and complete that is specific to your particular illness. Then if we decline further, in consultation with our physician, it could be extremely helpful to make sure that we have a DNR in place if we do not want to be resuscitated at that time in our serious illness. But how in the world do we get to this place where we need to make these difficult decisions and get these complicated documents sometimes in place? Well, in the last 10 to 15 years, as you know, there have been tremendous advances in medical and technological events, devices, and procedures that can prolong our lives. Things we take for granted now every day: antibiotics and medicine, ventilators, feeding tubes, dialysis. Our whole 911 system and EMS did not exist 15 years ago. There are unbelievable ICUs and advanced and unbelievable surgeries that can perform almost miracles to help critically ill and injured people. However, they often serve as a bridge back to life, but they can prolong our lives artificially. So what happens if a person gets stuck between life and death? Who makes the decisions? Physician? The family? A judge? If we withdraw life support, is that killing a person? When and for whom should we use these life-prolonging medical tools? In 1990, the federal government passed what's called the Patient Self-Determination Act, giving every person the right to make his or her wishes known about these life-prolonging measures in what we call a living will. That is a document where the individual makes clear to their medical providers what they want. All of these things, some of these things, or part of these things in combination with others. But in consultation with your physician, you can complete a living will. The Patient Self-Determination Act also provided us the opportunity to complete a healthcare power of attorney, which is an opportunity to appoint someone else who can speak our wishes for us if we can't say those things ourselves. Two extremely important documents to have on hand. When should I complete an advance directive? You must be 18 years of age or older, and when you're perfectly healthy or not. The best time is as soon as possible, because it always seems too early until it can become too late. So why should I complete an advance directives? So you can say now what your wishes would be for any end-of-life treatment, in case you cannot say it then. Or so you can say who you want as your representative, if you cannot speak for yourself. And so you can ease the burden for those you love and care about, if they ever have to face this situation with you. What exactly is a living will? Again, as I mentioned earlier, a living will, in a living will, you direct your physician, your healthcare providers, about the use of certain life-prolonging treatments. It is best completed in consultation with your physician, and it can be pretty clear about the specifics of what kinds of things you want or do not want to happen if you're in that kind of situation. What kinds of decisions do I need to make in a living will? These are simply examples. But as you think about these, in which of these instances would you not want your life to be prolonged artificially? If you had an incurable or irreversible condition that will result in your death in the near future, if you become unconscious and doctors determine that you will never regain consciousness again, or if you have advanced dementia or another condition that causes substantial, irreversible loss of mental function. Again, these are simply examples of the seriousness of the kinds of conditions that might happen that would behoove us to look at completing living wills and advance care directives. What is a healthcare power of attorney? A healthcare power of attorney is an advanced care directive. It is a document that names one or better two people to make healthcare decisions for you, again, if you are unable to speak for yourself. Those people must be 18 years of age or older. They must have decision-making capacity, and they cannot be a paid healthcare provider. Your physician cannot be your healthcare power of attorney, nor can any of your other healthcare providers. Your healthcare power of attorney has the right to start or stop life-prolonging treatments for you. They can choose your healthcare providers and facilities for you. They can review and share your medical information, and they can decide about autopsies and burial and cremation. They can authorize organ donations as per your special instructions. You may set limits on any or all of these powers and others as well. Your healthcare power of attorney should be someone who knows you well and who understands your goals and wishes. They should be someone who are willing to honor your wishes. They need to be somebody who can be a strong advocate for you when dealing with healthcare providers. And what makes an advanced care directive valid? Again, you must be an adult to complete it. You must have decision-making capacity when you complete it. Your document must be notarized. And in the state of North Carolina, that can be done by video due to recent statutes passed by the state of North Carolina until March of 2021. Because of the COVID complications, they made it possible to be notarized via video. Your document must have two witnesses. Again, because of COVID, that can be done by video, again, until March of 2021. What makes your advance directive really effective? If you talk to your loved ones, tell them what you want or what you don't want. Discuss with them your wishes and why you want those things. Number two, talk with your healthcare providers. Let your physicians know your wishes, what's important to you, what's not important to you, so that they are clear that you know and communicate to them the kinds of things you want or don't want. What else needs to be said? With the persons that you choose to act as your healthcare power of attorney, if you do so, again, this is the individual that has the power to act on your behalf if you are unable to do so. Explain your reasons to them. What is quality of life to you? At what point would life no longer have meaning or quality for you? Are there religious or spiritual values that guide your decisions? Share them with your healthcare power of attorney. Ask them if they feel comfortable and willing to follow through on your wishes. Finally, this is a copy of what we call the MOST form, the medical order for scope of treatment. It is that other advanced directives I referred to at the beginning of the talk that a physician completes when you are facing or in the midst of a serious illness. It is a document that allows and puts into legal form the goals of care very specifically about what kind of care that you want or do not want as that specific illness advances. And finally, this is a DNR, a do not resuscitate form, also called a goldenrod form in North Carolina. It is another advanced directive. It is written when a physician determines that the patient is at the end of life and that CPR, or what we know as cardiopulmonary resuscitation, would be futile. Finally, and again, perhaps most importantly, I have an advanced directive, not because I have a serious illness at this point, but because I have a family and I want to make it easier for them. AuthoriCare Collective can help you complete these documents. So if we can help in any way, again, we want to help tell your story and your loved one's story with our expert care. Thank you.
All right, thank you, Kevin. So we appreciate the panel's valuable information and sharing, being here and sharing that with us. I know we have had some questions come in, so I'm going to turn to Jennifer Harris and have her share a few of those questions with us.
Okay, Kevin, while I've still got you right here, one of the questions is, can advance directives be changed once they have been notarized and recorded?
Absolutely. As long as the patient is still alive and able to speak for themselves, they can change an advanced care directive at any point.
And one other, how does the most form stay with you? Do you carry a copy with you laminated?
That is an option. However, now there are several options to upload your documents to the web in a safe and secure manner. One of those, there are several companies that are actually doing this. One is called Vynca, V-Y-N-C-A. Another option is one called Mind My Health. They both offer the opportunity for you to upload these documents to the web so that your physician, if you are a hospital, or if you're in another state, in an ER, those documents can be accessed. You then do not have to remember to have them with you, or if by chance you don't have them with you. But those are excellent opportunities to make sure that they are accessible at any point in time.
Okay, thank you. And got a question also for Steve. Let me unmute you. Steve, you have a question. Can you explain the difference between testate and intestate succession when it comes to probate?
Excuse me. So testate means you have a last will and testament. So you've left a set of instructions in writing, again, saying who you want to receive your property, who you want to administer your estate, and any other conditions maybe that you put on a bequest. Intestate means when you pass away and you don't have a will. So when you pass away and you do not have a will, in North Carolina, your bloodline controls the disposition of your estate. So we have a chart that outlines, whether it's a spouse, children, grandchildren, so on and so forth, where, there's a living individual within your bloodline who receives your assets within the 5th degree. So it does stop. It's not indefinite. And so, again, with the will, you leave a set of written instructions outlining, who gets what and who manages your assets. Who probates your estate. Without a will, it's called intestate. In my opinion, it's better to have a will than not have a will. It's just easier. There are some saving benefits to having a will, but all is not lost if you pass away without a will.
Thank you. And Bill, I've got a question for you, please. My parents have created a trust, but I don't think it names a beneficiary on their assets. I'm the power of attorney. How can I find out who is listed?
So can you read the question one more time, because you said about a beneficiary in the trust? I think
my parents have created a trust, but I don't think they've named a beneficiary on their assets. How can I find out who is listed? I have power of attorney.
Yeah, well, the power of attorney goes a long way. So to me, I would backtrack that up the line to who the attorney was that did the work, and then find out from there. When you're not naming a beneficiary, if you set the trust up, our preference would be that assets would list the trust as the beneficiary of assets, because the trust is really the dictating of the wishes of the owner on how they want it dispersed. The job of the trustee is to make sure that it gets done correctly. So I would be taking that back up line to the attorney to find that information out. Steve, you agree? Got to go back to the source. You're muted, Jennifer.
Thank you.
You're welcome.
Steve, did you have a comment on that?
Yeah, I agree with Bill. With one caveat, if you have the trust document, there are specific rules though who information with a trust can be disclosed to. So if you have power of attorney, if I understood the question right, you can go to, like if it's life insurance, that's the beneficiary, the power of attorney should be able to reach out to the life insurance company to find out who the beneficiary is of, for the trust. But with the trust document, unless the POA is also trustee or beneficiary, it gets a little tough there with regards to disclosure, because trusts are supposed to be a private document, meaning obviously it's not for the public to have access to. So, the POA will have to have, either be a beneficiary or have some function as a fiduciary under the trust document in order to get any information.
Mm-hmm.
Thank you. And one final question, Kevin. Do you need a lawyer to complete an advance directive if the individual already has cognitive impairment?
Yes, I would recommend that you do approach an attorney at that point in time. I'm also going to ask Steve if he would to weigh in on this one.
So that's an excellent question. And I'm going to speak to North Carolina law on the matter. So even if a person's been diagnosed with Alzheimer's or some other cognitive deficiency, if you will, that does not mean under North Carolina law they cannot execute a document. The problem though is, most of those documents need notarization, and the notary is there to, one, confirm this is the person who is signing the document, but two, also that this person was competent when they signed the document. So if the person is having, let's say, memory issues, again, they are not necessarily under North Carolina law prevented from executing a document. We use what's called a lucid standard, if you will. So as long as a person is lucid and understands at the time they sign the document that they know what they're doing, that document is valid. In my opinion, as Kevin, I think, alluded to, that's probably best. It's probably best for an attorney to make that call in order for that document to stand up in court. So if somebody challenges that document and an attorney was involved in the creation and execution of that document, then more than likely that document will stand up to scrutiny if it's ever brought before a court of law. So again, even though a person may be suffering from some cognitive deficiency, that does not necessarily mean they can't do a document. The road just gets a little rocky when an attorney is not involved if it's known that the person who executed the document, again, has Alzheimer's or some other cognitive disease that may impair their, thought process.
Okay.
Thank you.
All right. Well, I think we're out of time, but first of all, I'd like to thank everyone for tuning in to our ACAP Guilford County program this evening. Special thanks to Steve Arrington with Arrington Firm, Bill Roach with Witchard, Roach and Associates, and Kevin Pearce with the ThoraCare Collective. We really appreciate them being here with us. Again, just a special thanks to our sponsors for this evening who made this possible, AARP and Caregiver Connect. Just invite each of you to join us for our program next month. It's going to be November 19th at 7 p.m. when we'll hear from Dr. Cheryl Greenberg with an overview of Alzheimer's and other related dementia. So to follow us in terms of our programming, you can visit us at our website, acapguilford.org. or you can send us a message at our email address at acapguilfordcounty@gmail.com. So again, thanks for being with us, and we hope to see you next month.